Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss about insolvency professionals. In the previous class, we have discussed about insolvency professional agency. So in the previous class, we have discussed the legal framework relating to IPA. Then we have discussed the eligibility criteria for registration of IPA. We have discussed about the paid up share capital requirement, minimum number of directors, etc. Okay. Then function and duties of IPA. Then we have discussed the governing structure. So where we have discussed that IPA must have managing director. Then they are expected to have independent directors, then shareholder directors. So that is how we have discussed the governing structure of IPA. Then we have discussed about registration of IPA. So if you want to go for registration, unless you are registered with IBBA, you cannot act as a IPA. Okay. Then disciplinary proceedings by IPA. So IPA is going to regulate the insolvency professionals. Then if any misconduct is there by the insolvency professional, IPA, Insolvency Professional Agency, is going to take the disciplinary proceedings against the IPA. So all these things we have discussed in the previous class. Today we are going to discuss about insolvency professionals. Okay. So let us discuss about enrollment and registered person to act as insolvency professional. Who can act as a resolution insolvency professionals? So as per section 206 of the Act, no person shall render his services as insolvency professional under this code without being enrolled as a member of insolvency professional agency. So who can be or who can act as an insolvency professional? Any person who is enrolled and registered person under the IBC and who is registered as an insolvency professional with the insolvency professional agency can only act as a insolvent professional under the legislation. Okay. Then if you observe section 207, which provides that every insolvency professional shall, after obtaining the membership of insolvency professional agency, register himself with the board. Okay, so here there are various stages are there. If you want to become the insolvency professional, you are expected to qualify the insolvency IP examination first. Okay, there are various modes are there. So you are expected to qualify the examination. Then subsequently you are supposed to undergo mandatory training hours. Then subsequently you will be admitted as a member in one of the professional agency, IPA. Maybe you can enroll with ICAA IP or ICSA IP, CMA IP. Okay. Then accordingly, you are supposed to be registered with IPA first. Then you are supposed to register with even IBBA also. Okay. If you want to practice as an insolvency professional, registering with IBBA is mandatory. Okay. Then the board may specify the categories of professionals or persons possessing such qualifications and experience in the field of finance, law, management, insolvency or other field as they deem fit. So who is eligible to become insolvency professional? The board, that is IBBA, is going to prescribe the qualification. Okay, so in the next in this class only, okay, in the next slide we are going to discuss the qualification. Okay, who can act as a insolvency professional? Those things we are going to discuss in the next slide. Okay. Eligibility. Regulation 5 deals with the eligibility. Okay. So what is the eligibility? Who can become the insolvency professional? If he has passed the limited insolvency examination within 12 months before the date of his application for enrollment with the insolvency professional agency. Okay. So you are expected to qualify limited insolvency examination first. Then within 12 months, you are expected to make an application for the enrollment. So there is limited insolvency examination is valid for, in other terms, it is valid for 1 year. So within 1 year, after qualifying the insolvency examination, you are expected to make an application and complete the training program, then enroll yourselves with the insolvency professional agency. Then he has completed a pre-registration educational course within 12 months from the date of payment of non-refundable application fee under the regulation. Okay, so you are expected to undergo educational course. Mandatory hours will be there. You are expected to complete. So after completing the educational course, okay, so you are expected to pay the non-refundable application fee also. Okay, then after his may be required by the board from an insolvency professional agency after his enrollment as a professional member. Okay, so you are expected to undergo the training also. Then successfully completed National Insolvency Program as may be approved by the board. So National Insolvency Program will be there. You have completed National Insolvency Program. That is one route. Or else successfully completed Postgraduate Insolvency Program as may be approved by the board. So there is a program called as PGIP, Postgraduate Insolvency Program, which is offered by IICA, Indian Institute of Corporate Affairs. Okay, so maybe you must have completed postgraduate PGIP program, which is approved by the board. Or else you are having experience as a experience of 10 years in the field of law after receiving bachelor's degree. So maybe you have or you are having PGAP program qualification, or else you are having the experience of minimum of 10 years, okay, in the field of law after receiving the bachelor's degree. Or else you are expected to have 10 years in management after receiving master degree. So if you are in the management, then minimum 10 years experience, okay, so in the management after receiving the degree, okay, in management, or 2-year full-time postgraduate diploma in management as per the norms. Okay, so AACT norms will be there. So as per the norms, you are expected to complete the PG. Then you are expected to have 10 years of experience in the management. This is one eligibility. Then 15 years is management after receiving bachelor's degree. Suppose if you don't have the master degree, then 15 years experience is required to be eligible to become the insolvency professional. Okay. Then 10 years experience as chartered accountant registered as a member of Institute of Chartered Accountants of India. Okay, so he should be a CA having 10 years of experience, or company secretary registered as a member of ICSI, or cost accountant registered as a member of Institute of Cost Accountants of India. Okay, so either he is having 10 years experience as a CA, CS, CMA, or as an advocate. Okay, so you are having either the person who wants to become the insolvency professional must have 10 years experience as a CA, CS, CMA, or advocate. If you look at the previous slide, 10 years in the field of law after receiving the bachelor's degree, 10 years in the management after receiving PG, 15 years after receiving the bachelor's degree. Okay, so if you are satisfying any one of these conditions, then you can write an examination. Then after that, if you qualify, then you can get you are supposed to undergo the training program, then get the membership with any one of the IPA. So as already we have discussed in the previous class, IPAs are there, so you are supposed to register with the IPAs. Now let us discuss functions and obligations of insolvency professionals, what they are expected to do. So section 208 of the Act, okay, so they are act as insolvency professional in the following matters. So what they are supposed to do? So they are supposed to act as insolvency professionals in the matter of fresh start order. So under chapter 2 of part 3, you can go for a fresh start process. Okay, so you can act as an insolvency professional there. Or individual insolvency resolution process under chapter 3 of part 3. Then CIRP process, that is what we were discussing in the last classes. Okay, so CIRP process, corporate insolvency resolution process. Here he can act as a resolution professional. Okay, then pre-packaged insolvency resolution process. So in the next classes we are going to discuss about PPIRP also, pre-packaged insolvency resolution process. So an insolvency professional can act as a insolvency professional in these matters. Okay, then individual bankruptcy process under chapter 4 of part 3, they are not yet notified. So individual bankruptcy process. Then liquidation of corporate debtor firm under chapter 3 of part 2. Okay, so in all these cases, maybe in fresh start process, individual insolvency, corporate insolvency, pre-packaged insolvency, then bankruptcy, individual bankruptcy, liquidation of the corporate debtor. So in all these cases, a person can act as an insolvency professional. Then let us look at the functions and obligations of insolvency professional. So he is having an obligation to take reasonable care and due diligence while performing his duty. Maybe he is an IRP, maybe he is a RP. So in the previous classes we have discussed in detail about the IRP and RP. So he is expected to take the reasonable care and due diligence while performing his duties. Okay. Then to comply with all the requirements and terms, all the requirements and terms and conditions specified in the bylaws of Insolvency Professional Agency of which he is a member. So as already we have discussed in the previous class, insolvency professional agencies, they are going to enroll the members. So if you wanted to be insolvency professional, you should be enrolled with one of the professional agency. That is up to you with whom you are going to register. So with one of the agency you can register. Okay. So each and every professional agency will have the bylaws. So you are expected to comply with all these bylaws, and apart from this, even regulations are also applicable to you. Okay. So to the professionals, so these professionals are expected to follow even regulations also. Okay. Then to allow the insolvency professional agency to inspect his records. Okay. Whenever insolvency professional agency, if they want to inspect the records, you should allow, as a professional, you should allow this professional agents. Okay. Then to submit a copy of records of every proceedings before the adjudicating authority to the board as well as to the insolvency professional agency. So whenever you are submitting any records, okay, so then you are supposed to submit the records to the NCLT, that is adjudicating authority, and also to the board, that is IBBA, and also to the IPA. So as per the law, okay, so not all the documents need not be submitted. So whatever may be the document that is required, so these documents must be submitted to the both IPA, IBBA along with adjudicating authority, that is NCLT. Then to perform his functions in such manner and subject to such conditions as may be prescribed. So we are having detailed rules and regulations are there. So in the rules and regulations, they are going to prescribe the functions. You are supposed to, as an insolvency professional, you are supposed to follow these terms and conditions. Okay. Then what are all the powers? So if you observe the insolvency professionals, okay, so the powers of insolvency professionals are very scattered. They are not there in one place. Okay. So these powers are there in various places. So that's why we have divided for our convenience, we have divided this into powers during the CRP, powers during the liquidation. Okay. So powers of the insolvency professional during the CRP. So first power is section 17. If you observe section 17, we have discussed already in the previous classes. Management of affairs of the corporator by the interim resolution professional. As already we know that, okay, so once the application is filed either under 7 or 9, 10 as the case may be of the IBC, okay, the interim resolution professional will be appointed by the adjudicating authority, okay, upon the recommendation by the financial creditor or corporator. In case of operational creditor, anyway there is an optional. Okay. So once a resolution professional is appointed, please remember the resolution professional is going to replace the board of directors. So that's why the resolution professional is supposed to manage the affairs of the corporator. So in case of CRP, he is going to replace the board of directors. Then management of operations as a going concern. So one of the requirement of under the IBC is that when IRP or RP is taking over the management of the company, okay, so they are supposed to run the company as a going concern. Okay, that is one of the essential feature of the IBC. Okay, then RP to conduct CRP and manage affairs. Okay, so CRP process. So in the previous classes we have discussed about the timelines within which you are supposed to complete. So everything he is supposed to comply. Okay, so he is expected to comply with all these rules and regulations, whatever we have discussed in the previous classes. Okay, so next, duties of the resolution professional. So section 25 speaks about the duties of resolution professional. So apart from this, he is having general duties also. If you, as already I told you, so these duties are not there in one place. Okay, so till now whatever we have discussed, so everything in the previous classes, whatever we have discussed, everything is done by the resolution professionals only. Okay, but for our convenience, let us have few points for the discussion. Okay, where which provides for powers during the CRP process. Okay, so take control of the corporator. So once IRP is appointed or resolution professional is appointed, okay, so he is going to take over the management of the return. Okay, so whereby he is going to replace the board of directors. So where he is going to replace the board of directors and he is in a fiduciary position towards the company. Okay, when resolution professional is replacing the board of directors, the resolution professional will be in the fiduciary position. Okay, we are having few judgments are there where it was held that RP is having the fiduciary position towards the company. Then custody of the assets. So the once the IP take over the management of the company, then immediately he has to take over and take the control and the custody of the all the assets, including the financial and operational records. Then operate the bank account. So once the resolution professional is appointed, as already we have discussed in the previous classes, so once the order is given, immediately it has to be intimated to the bank, so that banker is not going to pass any checks which were issued by previous management. Okay, then resolution professional is expected to have the power to do the signature, so that's why he is having power to operate the bank accounts. Okay, then collect and verify claims. Okay, so as already we have discussed, one of the basic duty of resolution professional is collect and collate the information. Okay, so he is going to collect and verify the claims also. Okay, so we are having various categories of creditors: operational creditors, financial creditors. Okay, so workmen dues other than the operational creditors. Okay, so the professional is supposed to collect the information and he is supposed to verify the claims, okay, from the creditors, and he is expected to update the list, okay, whenever he has received some information. Okay, then constitute the committee of the creditors. So already we have discussed all these things in the previous classes. So resolution professional is expected to constitute the committee of the creditors, then run the business as a going concern. So this is one of the crucial role of resolution professional. So he is expected to run the business as a going concern. Okay, so and to ensure that the business is run, the business is going on smoothly. So because generally one person cannot manage the entire company, that's practically impossible also. So that's why he can appoint other professionals and consultants and accountants. So depending on circumstances, he can appoint various people to assist him. Okay, so that's why in the previous classes we have discussed that the resolution professional is having power to appoint various professionals, and he is expected to, and he shall actually, okay, so he shall appoint the two valuers immediately after his appointment. Okay, so he is going to appoint various people to facilitate the smooth running of the business. Okay, then raise the interim finance with the COC approval. Suppose if resolution professional is of the opinion that company cannot be run, okay, so without raising the capital, okay, further capital may be required. In such cases, you can raise the interim finance. But please remember, whenever you are raising the interim finance, this has to be with the approval of COC. Okay, without the approval of COC, you cannot raise the interim finance. Then file the application before the adjudicating authority. So as already we have discussed, so once the CRP process is started, all the applications from the CD to the adjudicating authority must be routed through the resolution professional only. Okay, so the resolution professional, he is supposed to file an application before the adjudicating authority on behalf of the CD. Then invite resolution plans and present them before the COC. Okay, so once the resolution professional is appointed, so he is going to give the public announcement, then expression of interest, then subsequently he is going to prepare the prospective resolution applicants, then he is going to invite them to submit the resolution plans, okay, by giving the evaluation matrix and other things we have discussed in detail, all these things. Okay, then all the resolution plans must be placed before the COC for their approval. Okay, then these are all the various powers under the CRP process. Let us discuss few powers of the resolution professional during the liquidation. Okay, so powers and duties of liquidator are specifically, they are provided in the section 35 in detail. Okay, then access to the information, consolidation of claims, he is having power to have access to the information. Then consolidation of claims. So these sections you are going to discuss subsequently in detail in the next classes. Then take custody and control of all assets of the corporate debtor. So once the liquidation is started, then it is the responsibility of the resolution professional, that is liquidator. Okay, so who is supposed to take the custody? So he is supposed to maintain the estate. Okay, so debtors, this estate of assets. Then you are supposed to maintain all the assets. Okay, you are supposed to take the custody of all the assets of the corporate debtor. Okay, it is called as liquidation estate. Then evaluate and sell assets, including going concern sale or slump sale. Okay, so he is supposed to evaluate Okay, and he's supposed to sell the assets. Okay, as a going concern, he can sell the sale, he can have the sales, slum sale, so everything he can do. Okay, then investigate financial affairs of the corporate debtors. Okay, so during the liquidation process, so he is supposed to investigate the financial affairs. So that is how he is going to know the transactions, that is PUEF transactions, where he can avoid the transactions. Okay, so in the subsequent lessons you are going to discuss more about avoidance of transaction, where you are supposed to avoid. So there is called PUEF transactions are there. We are going to discuss more about this. Okay, so the resolution professional is having power to investigate into the financial affairs of the corporate debtor. Okay, then he may summon the person who may have information about the company's affairs. Okay, so during the liquidation, if he is of the opinion that someone else is having some information that is very crucial for the liquidation, then he may give the summons, okay, to any person to give the information. Then institute or defend suits and legal proceedings on behalf of the debtor. Okay, so once the liquidation process started, so if company wants to file a case against any other person, or if any other person is filing the case, then he is the person who is going to defend, or else he is the person who is going to institute if the company wants to file a case, because he is the person who is going to take the decision. So he is going to institute and defend the legal suits. Okay, then distribute the proceeds from the asset sales according to the waterfall mechanism. So in the subsequent lessons, you are going to discuss in detail about the waterfall mechanism. So as per the waterfall mechanism, okay, so once the liquidation process completed, so it is the responsibility of the resolution professional, that is liquidator, to distribute all the assets in accordance with the waterfall mechanism under section 53. Okay, then let us look at the role of RP as recognized by the judiciary. Okay, even judiciary also, they have recognized the role of RP in various cases. Okay, let us discuss few judgments. In the case of SBA versus Ramakrishnan, the Supreme Court, it was held that they have clarified the role of IPs under the moratorium. Okay, so where it was provided that this is also applicable to personal guarantors also. Then in another case law, Swiss Ribbons Private Limited versus Union of India, the Supreme Court held that they have recognized the central role that is played by the IP, because insolvency professionals are the people who are going to manage the affairs of the company, and they are the people who are going to replace the board of directors. So that's why the Supreme Court has recognized, and they are going to facilitate the committee of the creditors, and they are going to facilitate and to ensure that assets are realization of maximum assets. Okay, so that is one of the basic object of the IBC. Okay, so all these things can be done with the help of insolvency professionals only. So that's why the Supreme Court, they have recognized that it is the central role played by the IPs in the resolution process, and they have emphasized that they are expected to have the professional competencies. Okay, so upheld the constitutional validity of IBC. Okay, so in this case someone raised the question that is it constitutionally valid whether resolution professionals, because they can practice and they can appear before the NCLT, is it constitutionally valid? The court of law held that these are all specific people and specialized people who are trained in a particular manner to suit the industry requirements. So that's why constitutionally it is valid. Okay, then in another case law, Phoenix ARC Private Limited versus Paid Financial Services Limited, the NCLAT held that they dealt with conflict of interest. Okay, so where it was held that IP must disclose all possibility relationship, and it is a responsibility of the IP to ensure that he is independent. Okay, and he is not expected to have any interest, and he should preserve the neutrality. Okay, he should be neutral enough. Okay, so that is a role that is expected from the resolution professional. Okay, then in another case law, State Bank of India versus Veterinary Limited, in this case NCLT ruled that the resolution professional cannot be appointed if he is disqualified under section 29A. So if any resolution professional is disqualified under section 29A, then such resolution professional cannot be appointed. Okay, so let us recap what we have discussed till now. So in this lesson, we have discussed the legal framework relating to insolvency professionals. Okay, so what are all the various legislations, sections applicable? Then enrollment as insolvency professional, who can enroll as an insolvency professional? Then we have discussed the eligibility criteria, like they are expected to have minimum 10 years of experience as a CA, CS, CMA, as an advocate. Okay, then 10 years experience after the law graduation, and 10 years experience after your PG course. Okay, and 15 years experience in the management after qualifying your manager, after qualifying your bachelor's degree. Okay, like that we have discussed the eligibility criteria to become the insolvency professional. Then we have discussed about functions and obligations of insolvency professionals. Okay, then we have discussed powers of insolvency professionals. So when we were discussing the powers of insolvency professionals, actually the powers are scattered. Okay, they are not there in one place, but we try to discuss the few powers under the few powers of insolvency professional during the CRP process, during the liquidation process. Okay, then we have discussed about the judicial interpretation, or how judiciary recognize the role of insolvency professional during the either CRP process or liquidation process, as the case may be. Okay, so with this we have completed the concept of insolvency professional, the law relating to insolvency professional. Thank you.